Hello everyone, my name is Sarah Carnegie and I am the Director of Legal Projects at the International Bar Association. I am honoured to have been asked to provide a keynote speech and congratulate African Women on Board's Safety in the Workplace initiative, and I commend action to you all. Congratulations to those of you involved and thank you to the organisers and attendees of this important event. I'm very sorry that I can't be there in person, but sadly my diary commitments and the ongoing travel difficulties have meant it isn't possible. But I do hope we can manage to get together and meet in person in the not too distant future. The IBA is the global voice of the legal profession. We have over 80,000 members, 250 of the world's biggest law firms, and 190 bars and law societies. I run a team of lawyers and we work with members to deliver projects on the world's biggest issues and challenges facing the legal profession. One of our most significant areas of work in the last 2 years has been on bullying and sexual harassment. So the survey that we undertook in 2018 led to us publishing our report in 2019, and the results were shocking. The launch of the report was followed by a global campaign to raise awareness of the results, the stories, and to share our recommendations on what should be done to address this appalling reality. I will talk more about the results shortly, but it was obvious to see that the global legal profession had, and sadly still has, a problem. With 7,000 respondents, it was the largest ever global survey on this topic. The evidence was overwhelming. This is a global issue, with 1 in 3 women reporting having been sexually harassed in the workplace and workplaces failing to act. Of those who responded from the African continent, nearly half of the female respondents reported having been sexually harassed in their workplace. In tandem with this work, I undertook research and published a report in 2019 on the concept of sextortion, a component of the sexual harassment problem. Sextortion is a form of sexual exploitation and corruption which occurs when people in positions of authority, whether government officials, law enforcement, judges or employers, seek to extort sexual favours in exchange for something in their power to grant. This is a form of corruption where sex rather than money is the currency of the bribe. What we wanted to achieve was to raise awareness that this was a serious global problem and that the abuse of entrusted power for personal sexual benefit was never acceptable. We found it was dealt with in a variety of ways in different jurisdictions, whether as corruption, sexual offending, or simply workplace harassment in a disciplinary context, and each solution presented problems and disadvantages. So our core message was a cry for international recognition of this being a particularly insidious form of corruption which disproportionately impacted women and girls. When I travelled to Tanzania in late 2019, I spoke to lawyers and law students about these issues, and I was horrified to hear about the prevalence of sextortion among young women applying to work for law firms, with members of the audience telling me it was common to be offered a training opportunity on the basis of doing something for it. A quid pro quo exchange, which the young woman did not want to agree to, but simultaneously felt afraid that if she failed to do so, the consequences would mean she would have no job. What is true of both harassment and sextortion is that they are chronically underreported. From our survey, we found that 3/4 did not report, and this applied worldwide with little variation. No one has confidence in the mechanisms to report, and so much of this behaviour goes unchecked and unresolved. And why? The status of the perpetrator was often a very real concern, in addition to the fear of repercussions, career sabotage, and a sense that this behaviour was endemic and that the workplace perceived it as acceptable. When people report, usually via an internal workplace arrangement, over 67% felt that the response was insufficient or negligible, and 3/4 of the cases, the perpetrator was never sanctioned. If a policy was in place, and in 1/3 of cases there was no policy at all, there was a correlation with a reduced likelihood of sexual harassment by senior people, but it didn't seem to improve the prevalence of reporting, so it tells us that policies alone are not the answer. And what happens to the victims? The impact can be significant. 1/3 of those who experience sexual harassment leave or are likely to leave their workplace, and some consider leaving the legal profession for good. There will be absences, attrition in the workforce, a stressful working culture, and potential reputational damage for the firm. It does not make business sense to run a firm or organisation where people are bullied, sexually harassed, or made to feel deeply uncomfortable in any way, it may also be the case that someone is then committing a criminal offence. In the UK, we are seeing a steady increase in the number of cases being reported where major law firms are seeing senior people disciplined for harassment offences, resulting in fines, suspension, and often more serious outcomes. What is imperative is that the law firm needs to be seen to act, to mean it, and to change any culture that implies perpetrators can act with impunity. The same trend is happening in many other jurisdictions. Clients and new recruits will not want to work with firms that are not operating with clear and appropriate policies, positive and safe workplace environments, and genuine accountability when things go wrong. This now matters, and the workplace of today is both shaped and judged by diversity and inclusion priorities, which include well-being, safety, and respect for everyone. Our report concluded with 10 recommendations, and I urge you to read it. These apply to all organisations wherever they are based in the world, and they range from awareness raising to leading by example. This is the most important thing. Lead from the top, engage with everyone, and make a difference. The legal profession is based on its members being of good character. We must uphold the law and maintain the highest ethical standards. Harassment and sextortion are contrary to our professional obligations, are immoral and illegal in many jurisdictions. Such conduct is unacceptable in the modern legal workplace, and we hope organisations will heed the evidence and take action. Work being done by entities such as African Women on Board are hugely important in changing the tone and the conversation for the better. I've spoken at many conferences over the years, and I always leave with a sense of optimism. I hope the same will be true for you here today in starting to push for urgent and very real change. Thank you.